Broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. This is Rick Schweitzer. We still have a number of attendees signing on, so we'll get started in a couple of more minutes. Thank you. All right, good morning, everyone. This is Rick Schweitzer, and this is a special edition of the National Private Truck Council Washington report regarding private fleet responses to the COVID-19 pandemic. For those of you who are not familiar with our monthly government affairs teleconferences, I am the General Counsel and Government Affairs Representative for the National Private Truck Council. We have these teleconferences every month on the second Monday of the month. And we normally have a set of prepared remarks, which I will do today as well. On our monthly calls, we generally open the phone lines at the end of the prepared remarks and take questions or comments over the phone. Because we have so many attendees today, and this is such an issue or issues of extreme importance, we're going to ask that if you have questions to use the chat function in the GoToWebinar platform and to type your questions into the chat. And we'll try to make sure that we get all the questions either answered on the call today, or I will make sure that you get your question answered afterwards in an email offline. We only have an hour for this, and I want to take as much time as I can to get all of the information out to you. So with that, let's begin. I really want to address just two basic questions today, and there will be lots of parts to these, but the two basic questions that you need to think of are, number one, may I operate my truck fleet? Am I subject to some kind of restriction that tells us that we cannot or may not operate our truck fleets? And then secondly, if the answer to the first question is yes, what regulations apply? And we've got some literally up to the minute information for you from the Federal Motor Carrier Safety Administration that I think will help you and give some additional flexibility to your operations. So with those two sort of overriding questions in mind, what I want to discuss with regards to the may I operate question is the federalism approach to how the federal government is addressing this pandemic in general. So what we have is the Department of Homeland Security and its Cybersecurity and Infrastructure Security Agency. It has issued guidance on the essential critical infrastructure workforce. These are national guidelines that the Department of Homeland Security has set up, and they're quite comprehensive, and they're intended to be used by state and local governments when they are ordering businesses to close. It essentially comes down to who is exempt from any kind of a shelter-in-place order or a lockdown or a shutdown order. And I use all of these terms interchangeably. Obviously, they are different terms and have different meanings depending on how restrictive they are. But basically, when state or local governments are ordering businesses to close, DHS has set up some federal guidelines on who should be exempt because they are critical infrastructure businesses or critical infrastructure workers. Well, what if you're not on the list? How do you get on the list? Well, you have to request that from the Department of Homeland Security. Just this week, ATA got truck drivers and logistics personnel added specifically. They were basically included before, but they are now specifically included on the list of critical infrastructure workers. Now, the real question here, and we'll go through this in more detail, is the state's response to this with regards to their shelter-in-place orders. And it really comes down to, do the states adopt the CISA list of exempt businesses and workers or not? And if they don't, what are the differences between the state list and the CISA list? Because the CISA list, the federal list, is simply guidance. It's not mandatory on the states, and it is to be a tool used by the state or local government, but they are not required to use it. So it really comes down to, how does a company operating nationally or regionally comply with what we think is going to be a patchwork quilt of state restrictions and exemptions? And that's really what we're dealing with now. I will try to give you some advice on this. Information is coming in on this, and the state shelter-in-place rules are changing on literally an hourly basis. But I will try to give you the best advice I can on that. So going to the second question, what regulations apply? Well, we're going to go through the FMCSA's emergency declaration for hours of service and other regulatory exemptions. And it's been expanded once already, but it's like the Homeland Security list of exempted industries. This FMCSA emergency declaration is still a work in progress, and it's being expanded and clarified as we speak. The FMCSA also this week issued frequently asked questions to clarify what activity is included and what's not exempted under the emergency declaration. And then the FMCSA has taken a couple of other very important steps. First of all, they've issued a notice to the state driver licensing agencies on how to treat CDL expiration. And then just this morning, it's been a little over an hour ago, I got a waiver that the FMCSA has put out on CDL and medical exam requirements. So we will walk through that in a few minutes as well. The FMCSA has also given actually the DOT has given an update on drug and alcohol testing requirements for all modes of transportation. And then the Pipelines and Hazardous Materials Safety Administration has issued a notice for hazmat carriers to delay the requirements for recurrent hazmat training for employees. So we're going to walk through all of those items as well. As I said, there's a lot to go through. We've got an hour, so let's get started. All right, this Department of Homeland Security's Cybersecurity and Infrastructure Security Agency has developed comprehensive guidelines for state and local governments to identify critical infrastructure workers during this pandemic response. And as the federal government has done with all of its response to the pandemic, it sort of works out this way, and it's very, very consistent with the federalism structure of our government. The response efforts to the pandemic are locally executed, state managed, and federally supported. The federal government has not come in and mandated everything that the states and local governments should do. The states really are the supreme level of government at this point, and they are the ones that are implementing the responses to the pandemic. They are doing that with federal support, in this case, federal guidelines, often with federal money, but not with a federal mandate. So this list of critical infrastructure workers is guidance, but it's not mandated on the states. And the guidance document says that when it's not possible for remote work, and that's generally the case with all of your operations, obviously, it says that businesses should enlist strategies to reduce the likelihood of spreading the disease. Well, generally that refers you to the Center for Disease Control pandemic response guidelines as well. And I'm sure all of you have been accessing CDC resources for the past several weeks on this. The Department of Homeland Security also says that this includes, but is not limited to, separating staff by offsetting shift hours or days and social distancing, and these steps can preserve the workforce and allow operations to continue. Well, that's all true and fine, but I think that the CDC requirements are really what you should access in terms of protecting your workforce and your individual employees. One question that I got prior to the webinar today is, what are private fleets doing to protect drivers in team operations when they are required to have two people in the cab at the same time? And generally, I would say that involves using personal protective equipment, masks, gloves, and then following the CDC guidelines on wiping down the interior of the cab, washing your hands repeatedly and effectively, and just making sure that you're taking steps either to protect yourself and to protect your other driver while you're in the same vicinity, because obviously you're not going to be able to observe the 6-foot rule for personal space. That's one of the types of things that you need to consider as you go forward here. Who's on the DHS list? Well, it breaks down into, it's a little over a dozen industry categories, and within these industry categories, there are specific types of companies and types of workers that are included. It's healthcare and public health, law enforcement, first responders, food and agriculture is on here, obviously, energy, electric, petroleum, natural gas, and propane workers, water and wastewater, transportation and logistics generally, and now that ATA has gotten Homeland Security to include it, it specifically includes truck drivers and related logistics personnel. Public Works is on here, communications and IT, government operations and essential functions, critical manufacturing, hazardous materials, including cleanup, and then chemical manufacturing, financial services, and the defense industrial base. This is intended to be a comprehensive list of critical infrastructure workers who generally should be exempt as essential workers for any shelter in place or shutdown orders. Now, the problem is this list is advisory only. The federal government, as I said, is offering it to the state and local governments as a template to use in developing responses to the pandemic. But the feds have rejected the idea of a nationwide federal shutdown order. They've also rejected the idea of the use of the National Guard nationally to enforce such an order. And, it really raises the question, does the federal government even have the authority to impose a nationwide shutdown? They probably do, because they were considering it as late as Friday afternoon, as best I know. But it does raise some significant legal and constitutional questions. Nevertheless, they have decided to go the route of the federalist structure, which means that the federal government will provide assistance and guidance, but that the states are really the autonomous levels of government where implementation of the response occurs. The feds have left it up to the state governments to develop their own plans for shutdown or shelter-in-place orders. And because of that, the states may also develop their own list of essential businesses or workers that are exempt from their orders, which puts national and regional businesses in a real quandary. The states have had responses all over the map, no pun intended. California was one of the first. It issued a shutdown order, but it exempted those businesses that are on the CISA list. That's great. That's exactly what we hoped that the states would do. And we were also hoping that California would set a precedent with that order because it was largely the first and obviously the largest state. Didn't happen that way. Pennsylvania, New York, Connecticut, New Jersey, Illinois, they all followed very quickly with their own shelter-in-place orders, and none of them adopted the CISA list of exempt businesses. They each adopted their own list of exempted essential businesses and workers. Texas and Massachusetts have so far resisted statewide shelter-in-place orders. Texas has closed its restaurants and bars. Massachusetts has, in some cases, local governments are imposing their own restrictions. And I've just this morning received some attempts at creating a comprehensive list of all of these state shutdown orders. Virtually every state has some response to the COVID-19 pandemic and trying to limit human contact, trying to limit travel. And in many cases, they are closing down what they would refer to as non-essential businesses. And it's obviously having a devastating effect on commerce in those states. What we're seeing is that states don't really understand supply chains, or at least it's not recognized in their lists of exempt and essential businesses. For instance, Pennsylvania has a really, I think, naive and vague and difficult to understand list of, I think they call them life support industries or something like that. But basically they say it's okay for groceries to remain open, but there's no indication of how food and supplies are supposed to get to the grocery stores. There's no indication that food distributors or farms or grain suppliers or farm supply stores or anyone else who either develops products, finished products that go into groceries, or that develops inputs into those finished products are necessarily exempt so that the grocery stores can remain open. And I understand that we're all in uncharted water here. We're all trying to do things we've never done before. But it makes it very clear to me that these attempts by the state governments to come up with their own exemptions for essential businesses really are not very well thought out, even if they're well intentioned. And it would have been better if they had simply adopted the CISA list that the federal government put together. But unfortunately, it's too late for that now. So how do we make sense of this? Well, unfortunately, you've got to go state by state to determine what businesses may operate and what other restrictions might apply. And as I said, we're really in uncharted territory. But here's my advice to you. I would encourage you to read these exemption lists as expansively as possible, meaning that it should include, the exemptions should include as many businesses and industries and workers as you can possibly, in good faith, and in the spirit in which we are trying to operate, can interpret them. So that even if it says that groceries are exempt and nothing else is listed as an exempt business, you know that if you are in an industry that provides finished products for groceries, food products, other supplies for groceries, or the inputs to that, I would encourage you to read the exemption list to include your companies and industries as well. You're never going to be able to get permission on whether or not you can operate. State governors are not going to give you a golden ticket or a letter that says, yes, you're an exempted and essential business. There is no certainty here. You're not going to get something that gives you clearance to operate. And my thought is you should read these exemption lists expansively, and it's better to ask forgiveness after the fact than to limit your operations unnecessarily. Now, one of the things you might run into is that you might be operating, but your customers are closed. And if you can encourage your customers to read these exemption lists expansively as well, you might be able to encourage them to stay open while the pandemic response is ongoing. And obviously, I know all of you are dealing with a whole host of new human resources issues that you've not had to deal with before. Employees refusing to show up for work or to enter certain facilities, how you handle sick leave and vacation time for self-isolation. There are new requirements for sick leave that the federal government has just enacted. They go into effect April 2nd. I'll provide additional information for you about those requirements in the coming weeks in our weekly update, but for today's presentation, they're really too much for us to cover. But you also are dealing with keeping drivers qualified and licensed to drive. And that is something that we can address today, and we will. So let's go to the second question. If your trucks are operating, what rules apply? Well, the FMCSA has issued an emergency declaration. They first issued it March 13th. They expanded it March 18th. It exempts carriers and employees from the hours of service rules, but it's broader than that. It exempts them from all of parts 390 to 399 of 49 CFR, while providing direct assistance supporting emergency relief efforts related to the COVID-19 pandemic. So keep that in mind. It has to be while providing direct assistance supporting emergency relief efforts. Now, the exemption applies during the pandemic emergency or up to April 12th, whichever is earlier. If the emergency lasts longer than April 12th, I'm sure it will be extended, but that's the current expiration date. It is a limited exemption in that it does not provide an exemption from drug and alcohol testing or from the CDL requirements or from financial responsibility or insurance requirements or from hazardous materials regulations. And it also does not provide any exemption from vehicle size and weight requirements as well. Now, what's exempted? There are 8 specific categories of transportation that is exempted. Medical supplies and equipment related to testing, diagnosis, and treatment of COVID-19, supplies and equipment necessary for community safety, masks, gloves, hand sanitizers, etc. Here's the broadest one, food, and now with the expansion, it's food, paper products, and other groceries for emergency restocking of distribution centers or stores. Previously, it was just food and food at stores. Now it's distribution centers as well. And then we have immediate precursor raw materials, such as paper, plastic, or alcohol, that are required and to be used for the manufacture of essential items. So here's where I think you can look at things like food or other grocery items and say, if my business manufactures and distributes precursor raw materials, whether it's paper, plastic, or alcohol, but it's much broader than that. I would say grain that goes into livestock feed or other farm supplies would be immediate precursor raw materials that go into the food supply. You can't have food without these raw materials. And again, the FMCSA has asked us to read these exemptions in the spirit of which the emergency declaration was issued. And my suggestion is that you read them expansively so that you can operate exempt from these regulations while the emergency declaration is in place. Fuel is now included. Well, it's not restricted to any type of fuel, just as food is not restricted to any particular type of food. Fuel could be gasoline, diesel, propane, could be home heating oil, could be LNG, CNG, anything that serves as a fuel. Then we also have equipment, supplies, and persons necessary to establish and manage temporary housing and quarantine, persons designated for isolation or quarantine persons, and then persons who are providing medical or emergency services. Any of that transportation is exempted activity for purposes of this emergency declaration. Now, I said that it had to be direct assistance to the pandemic response. Now, direct assistance is specifically defined to include transportation and other relief services provided by a motor carrier or its drivers incident to the immediate restoration of essential services, such as medical care, or essential service supplies such as food related to the COVID-19 outbreaks during the emergency. So it's the immediate restoration of essential services for all of those items that we saw listed on the previous slide. Now, the FMCSA has made it clear that it doesn't apply to routine commercial deliveries. They have to be emergency deliveries. So if you, for instance, have a regularly scheduled delivery each week or 3 times a week to a customer, and you are making an additional delivery, that additional delivery, I believe, is considered a non-routine commercial delivery, and it would be part of the emergency response, and therefore it would be covered as direct assistance in this case. Now, direct assistance can include mixed loads as long as there is more than just a nominal quantity of qualifying emergency relief added to obtain the benefits for the emergency declaration. Here's the example that the FMCSA officials keep giving us. If you've got a trailer load of flat screen televisions and you put a pallet of water on the back of the trailer, just so that you can say, hey, we're taking water for emergency response, and therefore the entire shipment of flat screen TVs is considered subject to the exemption. No, that's not what they're talking about here. That would not be included as exempt under this emergency declaration. You can have mixed loads of exempt and non-exempt products, but you can't have just a nominal amount of qualifying emergency relief in order to get non-exempt items covered under the exemption. And then finally, the exemption terminates when the driver or the CMV that's used in interstate commerce is used not in support of the emergency relief efforts, or when the motor carrier dispatches a driver or the vehicle to another location to begin operations in commerce. And then when you terminate direct assistance to the emergency relief efforts, the carrier and the driver are subject to parts 390 through 399 at that point, except that the driver may return empty to the motor carrier's terminal or the driver's normal work reporting location without complying with the regulations. But before the driver goes out again, the driver has to have 10 hours off duty. Now, the FMCSA has issued some frequently asked questions on the exemption as well. The driver is not required to take a 30-minute break after 8 hours on duty because this is a complete exemption from the hours of service regulations. The hours worked under the exemption don't count towards your 60 or 70-hour rule. The driver is not required to take a 34-hour restart after completing direct assistance but you have to take 10 hours off duty and comply with the 60 and 70-hour rule before you may drive again in commerce. It made clear that livestock are covered as a precursor to food. And as I said, I believe that grains and other feed for livestock are included as well, even though it's not specific in the exemption. You don't need any documentation in the truck to operate under the exemption. You don't need a paper logbook or an ELD while providing direct assistance. If you have an ELD in the truck, however, they gave you 3 options. You can use the personal conveyance mode for the ELD, or you can use it in normal mode and just annotate to indicate direct assistance in the COVID-19 emergency, or you can turn off the ELD. You have any of those 3 options under this exemption. Now, FMCSA has also issued a notice to state driver licensing agencies. This came out in the last couple of days, and they've informed states that it's not going to jeopardize the state's federal highway funds if the state driver licensing agencies extend a learner's permit or a CLD that would otherwise expire during the COVID-19 emergency. This is going to be really important with what I tell you in just a few minutes. It's voluntary, however, and not mandatory on the states. So if they allow extended CDLs or CLPs, they have to promptly comply with the rules as soon as the emergency is over. States may now renew CDLs and CLPs online. And if a state doesn't change the medical certification status to not certified, or to downgrade CDL or CLPs for drivers whose medical exam certificate has expired, it's not going to jeopardize federal highway funds. See, this is one of those federalism programs where the feds have set up the standards, and the feds give money to the states to implement the standards. And in order to get the money, the states have to adopt the federal criteria here. And what the feds are saying is that we're giving you some flexibility in how you handle expired CDLs and learner's permits during this emergency. And we're also saying that if you don't downgrade to not certified CDLs that have expired when the medical exam has expired, then it's not going to jeopardize your federal highway funds. I put this last line on here. The carriers and drivers have to check with their states on how the state driver licensing agency is handling these issues. I think that we've gotten some additional clarity on that in the past hour, because in the past hour, FMCSA has issued a limited waiver for CDLs and learner's permit renewals and medical exams. And what they've said is that it extends the CDL validity to June 30th of 2020 for any CDLs that were due for renewal on or after March 1, 2020, and that otherwise would have expired. So if you had a CDL that was going to expire after March 1st, it's now automatically good to June 30th. Similarly, for your learner's permit, if it was going to expire on or after March 1st, it's good until June 30th, and the driver would not have to retake the general knowledge and enforcement test either. It also waives the requirement for the learner's permit holder to wait 14 days to take the skills test, and it waives the requirement that CDL and learner's permit holders and non-CDL drivers have medical exams and certifications, provided that they have proof of a valid medical certification that was issued for a period of 90 days or more and that expired on or after March 1st. So here's the thing. If your medical card was going to expire on or after March 1st, and it was issued for a period of 90 days or more, so you have one that's good for at least 90 days up to 2 years, and it was going to expire on or after March 1st, then this is a waiver that allows you to continue to drive with an expired medical card, because the FMCSA recognizes now that it's hard to get medical examiners to do the medical exams now, and that it's hard for state driver licensing agencies to renew CDLs and learner's permits, and so they have issued these waivers. The waiver requires, or it says that the requirement, that state driver licensing agencies change the CDL or learner's permit holder's medical certificate to not certified when it expires, is no longer required. As long as the driver had a CDL or a learner's permit with a valid medical certification or medical variance that expired on or after March 1st. So again, as long as you have a medical card or a medical variance that was good up to March 1st, then it waives the requirement that the states have to downgrade your medical certificate and downgrade your CDL or your learner's permit. And states don't have to opt into this procedure. Previously, with that notice to the states, it was really going to be incumbent upon the states as to how they treated this. But the FMCSA has made this clear that the states don't have to do anything to be subject to this waiver. It automatically applies. And I suppose the states still do have some discretion as to whether or not they adopt this waiver, but state driver licensing agencies have generally been very good at trying to provide flexibility to companies as well. So my expectation is that states are going to adopt this waiver for CDL and learner's permit holders and for expired medical certifications. And the FMCSA has also issued a non-enforcement directive on these requirements. The non-enforcement directive has gone to FMCSA employees, but state agencies are partners with the FMCSA on enforcing these items, and this waiver covers the states as well. And then finally, the FMCSA will continue to recognize the validity of licenses issued by Canada and Mexico if they issue similar notices extending the validity of medical exams and medical certifications, just like the FMCSA has done. So they're trying to grant some flexibility so that drivers are not forced to scramble around trying to find a medical examiner or a state driver licensing agency that's going to make sure that their medical certificate or their CDL remains valid. This gives them an extension on the CDLs until June 30th and an extension on the medical exams until this emergency is ended. In addition, DOT, not just the FMCSA, but the Department of Transportation, so this came out of the Secretary's office, has issued some guidance on its drug and alcohol testing rules. And they understand that there are problems with testing sites being unavailable and not having breath alcohol technicians or MROs or substance abuse professionals. So DOT has set out guidance that says that you should make a reasonable effort to locate testing facilities and professionals to help you. And as a best practice, they suggest maybe moving to mobile collection services for required testing if fixed site collection facilities are not available. I don't know if that's a realistic option or not, but that's what they suggested. It says, though, that if you're unable to conduct DOT drug or alcohol training or testing due to supply shortages or facility closures or quarantine requirements or any other impediments, you're to continue to comply with the existing applicable DOT agency requirements and to document why a test was not completed. So if there's, for whatever reason, you can't meet the FMCSA requirements for drug or alcohol testing, document why the test was not completed. And 6 months from now, if a compliance review is being conducted, you'll have a note in your file as to why you missed that test. And my expectation is that there will be no enforcement action. It also says that if training or testing can be conducted later, then you're supposed to do so in accordance with the FMCSA regulations. So that, for instance, reasonable suspicion training for supervisors, just do that at the next available opportunity. Or random testing. You're required to test randomly for drugs at 50% of your workforce, but you're not required to test at any particular interval. Some companies test on a monthly basis, some on a quarterly basis. This just says put it off until later in the selection period. As long as you meet the annual requirements, then you'll be good to go on the random testing for both drugs and alcohol. But you otherwise have to meet the applicable FMCSA regulations. Now, this says, in addition to what I just discussed, that if employers are unable to conduct testing due to unavailability of resources, the FMCSA regulations continue to apply in this case. And here's the most important bullet point in all of this. They're not letting you out of the pre-employment drug test requirement. You still need a negative pre-employment drug test before you allow a prospective or current employee to perform any DOT safety sensitive functions. So you may not let a CDL driver operate your commercial motor vehicle without a negative pre-employment drug test. That has not been waived. Then they also say that if employees express concerns about health risks associated with going to collection sites or the testing process, that you should see if there's any flexibility. And as I said, the FMCSA requirements do give you some flexibility on things like the dates for random testing and also for supervisor training. But ultimately, it says it's the employer's responsibility to evaluate the circumstances of the employee's refusal to test and to determine whether or not the employee's action should be considered a refusal under 49 CFR 4355. So it's still your obligation as employers to determine whether or not the employee is acting essentially in good faith. Is the employee expressing realistic and good faith concerns about health risks, or is the employee just trying to use that as a pretext for avoiding a drug screen or a alcohol test where the employee thinks that the result's going to be positive? I'm not sure how to advise you on where to draw that line, but it is still your obligation to do so in addition to your medical review officer as well. And finally, DOT asks employers to be sensitive to employees who indicate they're not comfortable or are afraid to go to clinics or collection sites. And they ask you to verify with the clinic or collection site that it's taken the necessary steps to minimize the risk of exposure to the virus. So they do give you some flexibility here to be sensitive to employees, and maybe that's your guidance on how to handle a driver who doesn't want to go for a drug or alcohol test. Again, I think if you note this in the driver's file and you're subject to a future compliance review, that I suspect the FMCSA or the states will consider that accordingly. Then finally, I just wanted to mention PHSMA's recurrent training. PHMSA, the Pipeline and Hazardous Materials Safety Administration, has decided to temporarily halt enforcement against shippers and carriers that are unable to comply with the recurrent training requirements for employees under the hazmat regulations. This only is recurrent training. It doesn't apply to initial training for new hazmat employees. You have 90 days to conduct that training. And it also doesn't exempt you from any other obligations under the hazmat regulations or applicable laws that apply to hazardous materials offerors or carriers. But for recurrent training under the hazmat regulations, you basically are not going to be subject to the requirements until the emergency is over. So that's what I have at this point. I know that you have lots of questions. I know there's some new information that we have covered here. Let's see what we have in the way of chats. Or Serena, how would you like to go through the written questions and open your mic and read them off to me so I can answer them?
Sure. Okay, for question 1, if an exempt driver finishes delivery, are they still exempt when running empty back to get another exempt qualified load?
Yes, in fact, I think it was either the declaration or the FAQ says that the exempt driver can run empty back to the place of origin, the distribution center, either to pick up a commercial load that is not exempt, or in your example, to pick up another exempt load. And regardless, that empty run is exempt from all of parts 390 through 399. Okay.
Next question. We are seeing medical professionals turn our drivers away because they deem DOT physicals as non-essential.
Well, now you have a waiver of that requirement. If the driver's medical certification was going to expire after March 1st, then the driver can continue to operate during this COVID-19 emergency declaration without a valid medical card. So you have some relief from that requirement.
Are hazmat and other endorsements extended also until June 30th on the CDL?
It did not say specifically, but yes, I mean, it makes no sense to extend the CDL without the hazmat endorsement or another endorsement. So I'm going to go out on a limb here and say absolutely yes.
Is there exemption from food safety? Oh, hold on. Is there exemption from Food Safety Modernization Act with the FSMA as it applies to shipper or carriers?
Well, the only exemptions that the FMCSA can grant are from FMCSA requirements. So to the extent that the food safety requirements are from another federal agency, no, you are not exempt from them unless they are specifically waived or exempted by the implementing agency.
A lot of questions as far as what counts as exempt. So let's see. We are a food service company that manufactures and delivers foods to our restaurants. Does that qualify as a food carrier in an essential environment?
To the extent that your restaurants are still open, I mean, the exemption really applies to emergency food deliveries. I think the answer is yes. And again, I'm offering that in the spirit of expansiveness and trying to make sure that the economy is not stifled unnecessarily during this emergency. So if I were in your shoes and advising you as your company lawyer, I would take the position that we can, in good conscience and in good faith, justify operating under the exemption. Yes.
Okay, we've had a couple of questions about the new hire DOT road test requirements. What are your recommendations there?
You know, I don't have one. That came in prior to the webinar, and I'm curious as to what other private fleets are doing to conduct DOT road tests for new hires. So if anyone can provide me information or a best practice there after we go offline today, I'd be happy to share that with those of you who have that question.
Are all states allowing drivers with medical cards expiring to drive with an expired card?
I believe so. The states do have discretion not to, but I think there's absolutely no incentive or indication that the states won't adopt that approach. So I think that it's reasonable to assume that your state would follow the FMCSA guidance on that.
We had a comment come in as far as the road test. One company said that they are doing ride behinds for theirs.
Ah, that's a good thought. Okay, thank you for that suggestion.
Let's see. You made reference to leave and sick leave legislature changes that will be covered later. Can you reference an area that we can research these changes prior or provide the specific code for research?
That was part of the federal emergency package that I think it was part 2 of the congressional package addressing the COVID-19 response. Honestly, if you just Google sick leave legislation, you'll find a number of law firms and other groups that have done synopses of this. I tell you, the best one I found was by the employer law firm Jackson Lewis. That's Lewis Lewis. They did a very good synopsis of the sick leave policies that are included in the new legislation. That's probably the best place to start.
What about IRP renewals if states are unable to process and IRPs expire?
I just saw a notice from the Truck Renting and Leasing Association on that this morning, and apparently the IRP board is aware of this issue, and they have had a number of calls trying to figure out the best way to either grant extensions for IRP registration or to allow companies to pay on a payment plan. They understand that just imposing these registration and fee requirements up front might impose some tremendous cash flow concerns on companies. And so they are working through a solution. I don't think we have it yet, but it's in the works.
Is the exemption for medical certificates also good until June 30th?
It's not limited to June 30th. So I believe it is extended until the end of the COVID-19 emergency, which for purposes of the other emergency declaration was until April 12th or until the emergency continues. So I think it's basically until the end of the emergency. And at that point, then the states and presumably drivers are going to have to work as readily as and as quickly as possible to get the medical certificates updated. So I don't think you're going to have 24 hours or 48 hours, but you're going to have an obligation to get your drivers medically certified as quickly as possible.
Do you have a recommendation for team operations that don't have access to proper PPEs right now, the personal protection equipment?
Well, I mean, PPE is the best way, I think, to do it. I would suggest, scrubbing down the cab, obviously, and avoiding as much contact as you can. And following CDC guidelines on providing personal space to each other, but that's hard to do when you're sitting next to each other in a cab. I know. I'm really not sure of what else you can do other than PPE on that one.
We've had a few more comments come in about the road test. So one company said that they use a dash cam and had the driver speak into the camera with a turn-by-turn, i.e. looking ahead, calling out cars and other hazards. And then our company, a second person, our company trains drivers for the first 2 to 4 weeks and completes a final road test upon completion before allowing the driver to be dispatched solo.
Terrific. Thank you for those suggestions. Those are great ideas.
Just to let everyone know, we currently have just the slides themselves available for download on our website, and then we also hope to provide a recorded copy of the broadcast, also available for download on the NPTC homepage following this call. Okay, one more question. What about state permits, hazmat, or NY HUD, for example?
Those are not subject to federal exemptions, so that you would have to go on a state-by-state basis there.
Does the medical exemption cover technicians who are working on commercial equipment?
It applies to anyone who has a medical certificate to operate a commercial motor vehicle.
Okay, here's an hours of service question. They run under declaration out to 9 hours, return trip was 9 hours, driver is fatigued at 7 hours. Carrier gives them 10 hours off. Driver returns to duty for remaining 2 hours. Once back, does driver still need to take an additional 10 hours off?
Well, that's a good question. The driver under the exemption has to have 10 hours off before operating a commercial load and has to comply with the 60 and 70 hour rule going forward as well. So doing that math makes my head hurt. I don't think your specific example was addressed, but as long as you can conclude that there's 10 hours off before the driver takes the commercial load, then you'll be in good shape.
If we are unable to send a driver for a random, can we not use him?
If you're unable to send a driver for a random test, you can still use him because there's no requirement that you give a random test at any particular time. So what DOT is suggesting is that you put off the random tests until later in the testing year when hopefully the collection sites will be open and drivers will be willing to go to them.
Has there been any discussion of relief of gross vehicle weight limits?
Not that I have heard of. Again, that's something that would have to come from the Federal Highway Administration rather than the Federal Motor Carrier Safety Administration, or it could have been done at the state level. I think it was the state of Illinois that issued a vehicle weight exemption during this emergency. Someone sent that to me. That's the only state exemption that I've seen. But no, I don't know of any discussion at Federal Highway on revising the weight limits or vehicle dimension limits.
What about annual MVR reviews?
There's been no discussion of waiving the annual MVR reviews. I suppose you could argue that while a driver is operating under the exemption, he or she would be exempt from Part 391, which includes that. But if you're operating just on a regular commercial basis, you still have to be subject to the annual MVR reviews.
Is a driver under the post-accident drug testing requirement while transporting an exempt load?
Yes, because the exemption does not waive the drug and alcohol testing regulations. So if a driver has an accident, then the driver is still subject to post-accident testing. However, if a testing facility is not readily available, the drug and alcohol testing guidance says that you document that and that you do the test essentially as soon as possible. And again, I think you will get some flexibility in the event of a compliance review somewhere in the future. But my suggestion would be to try to find a facility to do the test. If it's not available, document that and put that in the driver's record.
Okay, last one since we're running up here on an hour. Can you repeat how long extension for medical certificate was? Apparently the sound cut out.
Oh, sorry. The medical certificate is not limited to June 30th, like the CDL waiver. So essentially, medical certificates that expire after June or after March 1st are going to continue to be valid. until presumably the COVID emergency is over. So at some point, the FMCSA is going to say, the emergency has ended and we now require drivers and employers and states to come back into compliance with the medical certification requirements and the driver licensing requirements that incorporate the medical certification. So whether it's April 12th or May 12th or some other time period, your medical certificate, if it normally would have expired after March 1st, is going to be valid while this emergency lasts. That's the best advice I can give you. Is that all of the questions?
Well, let's do, someone asked, what is the regulation number for the new road test requirements that you were speaking of?
I don't think that there is a regulatory site for that. I think that this is just companies that are trying to comply with the road test requirements as they are currently written. Maybe I misheard you or misinterpreted your question, but if I did, please email me after this and I'll respond to you offline.
Okay, two more. Do drivers have to have a copy of the waiver in the truck?
Nope, you don't need a thing.
Okay, last question. Has any private fleet adopted or considered taking temperature of drivers or workers when arriving to work?
You know, I haven't heard of any private fleets that are screening drivers or any for-hire fleets that are doing that either. I've gotten this question from time to time from some of my other clients as well in transportation. And I even got the question from bus companies whether they should try to screen their passengers. I'm not sure that you have qualified personnel who can do this. Screening at airports, for instance, is typically by health professionals who do this. Most of them have been certified by the World Health Organization. So I'm not advising that anybody do this. There's certainly nothing that stops you from doing this except cost. But I don't know of any companies that have taken this on as a way to try to determine if drivers are symptomatic before they get in the vehicle. And with that, I'd like to conclude and just say in closing that I know we've all been asked to step up to the plate because of this emergency, and we're all being asked to make decisions that we've never made before, and perhaps even to take some risks that we've never taken before. And I'd just like you to know that I recognize your extraordinary efforts that all of you on this call are making. I absolutely know that you all can meet this challenge. And I certainly hope and pray that this emergency is over soon for all of our sakes and for the sake of our country and frankly, our planet. And I'd just like to say that if there's anything that I can do to help you operate your vehicle safely, please let me know. Call me, email me, and thanks for joining our webinar today.